Welcome to The Print. There seems to be a growing buzz around a Uniform Civil Code or a UCC, of course, with Article 370 having been abrogated and the Ram temple in Ayodhya well on its course. A UCC or a Uniform Civil Code seems like one of the last few pending items on the BJP's manifesto promises. The buzz also, of course, is centered around the Law Commission of India inviting opinions and comments from religious bodies and public and different stakeholders on the UCC. But of course, all of us know that this debate and discussion isn't anything new. In fact, over 70 years ago in 1948, this debate also manifested itself in the Constituent Assembly, not just when the provision around UCC was being debated and discussed, but also in the demand for the Hindu Code. Now, the Hindu Code was piloted by Dr. Ambedkar with Jawaharlal Nehru in the cockpit. It intended to provide a civil code to bring together various Hindu personal laws, but of course it faced a lot of controversy and debates. In fact, some called it an attack on the Hindu religion and an atom bomb on Hindu society. The laws finally came in the form of 4 different laws in 1950s, and these are the 4 laws that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apurva Mandhani. We have with us Bhadra Sinha. You've seen both of us in various episodes of this show, and we have with us today's expert is Supreme Court lawyer Archana Pathak Dave, who will be taking you through these 4 laws, the need for the laws, and will tell you what these laws actually say. Thank you so much for joining us, Archana.
Thank you for having me over. Thank you.
So Archana, let us just straight away start with talking about why was the need felt to have a Hindu code, and why was it that the Hindu community was kind of chosen for this purpose?
Well, Bhadra, I heard the introduction that Apurva had given just now about UCC and the latest buzz thing about the 22nd Law Commission inviting suggestions for the Uniform Civil Code. See, earlier this practice was once done in the year 2018. The suggestions were called, but somehow things didn't work out. And now again, it's a fresh start again. The public is being called for. And the basic reason behind this is that, see, Article 44 has always been there in our constitution. So Ambedkar, if you go through the Constituent Assembly debates, Dr. Ambedkar was from the very beginning was in favor for a uniform civil code, uniform Indian family laws, you can say. But somehow there were a lot of negative things being said about the fact that the personal laws will then lose their importance, or the culture, the ethnicity of our country will somehow be backed out if you have a uniform civil code. So ultimately, I mean, he just thought that maybe today, I mean that time, this is not the right time, but maybe in future. So that is why he kept Article 44 in the Directive Principles of State Policy, and he said that later on maybe when the time is right, when people have understood enough, because that we had just come out of a partition. And see, right from the British era, the policy of appeasement of the minority people, especially the Muslims, had been, because the basic idea of Britishers was divide and rule. So they wanted to appease minority, and that is how they ruled over us. Now, when this Uniform Civil Code thing was talked about in the Constituent Assembly debate, Dr. Ambedkar and Pandit Nehru also, he felt that probably this is not the right time. We've already come out of a partition, and so this was in the DPSP. And Hindu Code Bill, of course, there was a lot of tension even then. Hindu Mahasabha opposed it, but then it was taken, it was still gone ahead, and we see that it was a positive step, and codification of laws in no matter takes away the rights of minorities. We have seen that, we have done that, and we have seen that. It was done with the majority of the population. Now, the second thing is, if you don't have codified laws, what happens is you are actually putting down, it's my personal view, as well as you would also agree with me, that it's the rights of women and children which are jeopardized. because there are not enough mechanism available when you have the rights in marriage, say you have the grounds for divorce. So all these things actually take away the rights, the equality of between a man and a woman. So I feel that is the main reason why I personally also feel an advocate for a uniform civil code. See, we already have a uniform penal code for everyone, doesn't matter whether you belong to which religion, but then the penal laws are applicable on each and every person. So it's the same way. You can of course have some things which are essential practices of your religion that you can keep out, but general things like the grounds for divorce, marriage, adoption, succession, all these things, they should be codified, they should be brought under one umbrella, so that no woman is being looked down upon just because she belongs to a particular religion.
So are you trying to say somewhere that the codification of the personal laws or the practices, religious practices in the Hindu community, the reason why they were codified was to kind of eliminate the inequality that was in practice or in vogue as far as women are concerned? Was that one of the main objectives for the codification of the Hindu religious practice?
Yes, yes. In fact, let me tell you about bigamy. So even in Hindus, polygamy was practiced in some parts, and it was quite in vogue. But when the Hindu laws were codified, and we had a section, so in the Hindu Marriage Act, we have the punishment for bigamy. After that, no Hindu can have more than one wife. So this is this answers your question, that this was the main reason, and also there were some practices which were in vogue, which were detrimental to the interests of women and children in large.
Can you just highlight some of the practices if possible, if
And
it
all
is
the
possible?
four laws, and also highlight briefly the provisions of these laws.
Maybe we can start with the Hindu Marriage Act. So Hindu Marriage Act 1955, and if you see that the section 3 talks about the degrees of prohibited relationship, because in Hindus we believe that we have certain degrees where we cannot marry. So 3 degrees from the mother's side and 5 degrees from the father's side. So these are called the Sapanda relationships, and these are prohibited. So you see that even that part where you say that essential practices have to be taken care of, that is being taken care of even when a codification happens. So that argument that it would take away all your religious practices is not actually true. So that is section 3, and then you have section 5, which is conditions for a Hindu marriage. Now it says, I'll just read this section for you. It says, a marriage may be solemnized between any two Hindus if the following conditions are fulfilled, namely, neither party has a spouse living at the time of marriage. So polygamy is ruled out here. Then it says, at the time of marriage, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind. Then anybody who is not able to give a valid consent, then insanity, then of course the age is there, 21 years and 18 years. So that's an age where we feel that the person is able to take decisions on their own.
So just to pause over here, Archana, when you talk about the particular age aspect, so what was the practice before the Hindu Marriage Act actually came into being? Was there any age limit as far as the marriage was concerned in the Hindu community? And that the law kind of at least provided a threshold as far as the age limit is concerned?
Yeah, the law did provide. There was no age limit as such, even in the Hindu community. So when the Hindu Marriage Act came, 21 years for a boy and 18 years for a girl. So it was basically
what was the rationale behind having an age limit?
That you should be able to apply your mind. You should be able to maybe complete your studies. You should be able to do something on your own. At least that minimum 18 years. When a girl becomes mature enough to take independent decisions, of course, and maybe that's the reason that 18 and 21 for boys, because it's said that the maturity level of boys and girls is it differs. So 18 was kept as a minimum so that you can take your independent decisions, you can complete your studies, you can decide about your future, and also medical reasons. because after marriage you're going to have children. So medical condition that your body is actually ready for that is also very important.
So, this is vis-a-vis the Hindu Marriage Act. Can you just throw some light on the Hindu Succession Act? How did it kind of provide, equal opportunity to the women as far as succession is concerned?
Yeah, I just wanted to highlight two more important things about Hindu Marriage Act, because there the next thing which is very important under the Hindu Marriage Act is the divorce. And also there is a provision for divorce by mutual consent, which is not there in all the other minority communities, especially if you talk about Muslim law. The women don't have the equal grounds for divorce. So under the Hindu Marriage Act, one is registration of your marriage is compulsory, and second is registration is required to assert your rights. Tomorrow no one should say that, we don't know whether even both of you are married or not, if you're not able to prove that you're married. So registration was a very important thing which was put into this act, and second was divorce. Now the grounds of divorce, if you see, they are kind of equal, and in fact tilting more towards the women. So that was very important. And if you see section 24, I believe this is a very important section because it talks about the maintenance during a divorce proceeding is going on, and even permanent alimony. So the maintenance was kept in the Hindu Marriage Act to see that the woman doesn't suffer. During when the divorce proceedings are going on, then it is the duty of the husband to maintain the wife. So that was one. And if I can read it, and it is a gender neutral law. So either wife or husband, it's not that only the wife has to be given maintenance, but even the husband. Just see, I'll just read one line. Where in any proceeding under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding, it may on the application of the wife or the husband.
Or the husband, yeah.
So it is gender neutral.
Right. Since you mentioned divorce and since we're having this discussion, could you also tell our viewers about how the grounds of divorce also may have evolved, especially with the recent Supreme Court ruling on irretrievable breakdown of marriage coming in as a ground for divorce? If you could tell our viewers a bit about that.
Yeah, see, irretrievable breakdown of marriage is no ground for divorce. But now with the Supreme Court ruling coming in, they have actually held. See, in my own experience, I have felt this, that the grounds of, suppose this, one of the ground is that the husband has to prove cruelty. In order that if the husband approaches the court for a divorce, then the husband has to prove cruelty by wife. Now imagine in the setup that we live in today, a cruelty by wife, how would, I mean, if you just see the physical aspect, it's not possible. Maybe we can leave certain examples, but it's not possible for a wife to maybe hit the husband so hard that he would have certain bruises and there'll be a medical report and he'll be able to say that yes, I am subjected to cruelty. But cruelty by words, a person can be so cruel that just by words he can actually shake the mental level of the spouse. So cruelty was very difficult to establish. Now, when the husband used to file a divorce and he was not able to establish that, and the wife is not ready, then you would not get divorce, even though you are living separately for years together. Now, this judgment specifically talks about the mutual consent. Now, if both the parties are agreeable, earlier we used to have different decisions from different courts. So some of them saying that even if both of you agree, but the ground can be not irretrievable breakdown of marriage, because that's not the grounds of divorce which is mentioned in the act. Right. But now the court saying this, that yes, that is also, see, the conditions of the society keeps on changing. If you talk about 50 years before, probably this was never a ground. I mean, our parents never said that once you get married, it can't be worked out. They were always like, no, you should work it over, let's work it over. So now this ground, both the husband and wife, well educated and independent, financially independent as well. So now this thing is quite in vogue, that two people after some time they come to a conclusion that no, we are not ready. We are not.
So like a judicial push to keep up with the society, for the law to keep up with it.
Law doesn't operate in vacuum, so it has to be abreast with the societal needs, the changes in the society. So I think it is a very, very good judgment.
So that's a very positive about codification of laws, at least, you know, if you codify personal laws to keep away the regressive practices, then the laws also keep, you know, they stay abreast, at least through judicial interpretation, they stay abreast with the, with the developments happening in the society, with the evolution of the society.
That's correct. That's correct.
I guess that is another positive aspect. So, Archana, how about coming to the Hindu Succession Act now? So, as I asked you earlier, how did this kind of do away with the inequality vis-a-vis the women? And did the codification actually do away with the inequality or not?
See, Hindu Succession Act 1956, the most important section there is section 6, which said, but however this was amended in 2005 when the women were also given equal rights, and today I'll just also briefly mention about the two most important judgments which have actually given women equal rights for the properties where the property aspect is concerned. So, in 2005 there was an amendment which said that if the father is alive and the daughter is alive, the threshold was December 2014. So, from 2015 onwards the women would get equal rights. Yes, in the property. That was Prakash versus Phulvati. It was a 2-judge bench decision, and then thereafter there were 2-3 more decisions coming in, and the Honorable Supreme Court felt that no, this threshold of the date that you have given is actually not correct, because maybe you are born before that. So a retrospective effect of the amendment was taken care of, and a 3-judge bench of the Honorable Supreme Court in Vinita Sharma's case, I have this thing also, but it was Vinita Sharma versus Rakesh Sharma. Okay. There it was a reference actually because of Prakash versus Phulvati, and there were 2-3 more judgments. There was quite a confusion going on that what happens if the father is dead but the daughter is alive, and there is a confusion that even though she is born before 2005, but she would not be given because the father is not alive. So, just there was a reference to the Honorable Supreme Court, and the Honorable Supreme Court came down and said that this date is the date of the amendment, but from now on in fact before 2005 the daughters would get equal rights. They will be treated as co-partners and they will be given equal rights. I can just share with you the first, how the court answered the reference. They say the provisions contained in substituted section 6 of the Hindu Succession Act 1956 confer status of co-partner on the daughter born before or after the amendment in the same manner as son, with same rights and liabilities. Now, the court is talking about both rights as well as liabilities. Under Hindu law, we are bound, the daughters are bound to maintain even the parents. That also is gender neutral. The Hindu the Hindu Maintenance Act, that says that you have to maintain your children as well as your aged parents. So, that is again gender neutral.
So, Archana, before this judgment came into, was pronounced, wasn't the Hindu Succession Act taking care of this aspect about, daughters being equal partners when it comes to succession rights?
No, actually there were degrees of how the property would devolve, and when the daughter would be given rights. But this amendment actually took care and gave equal rights. But the only problem with that amendment was the date.
Date. It would have been applicable after 2014, right? Or 2005?
2005.
Okay, so yeah. The second Supreme Court judgment actually said that not just 2005, this amendment should be implemented with retrospective effect.
Yes.
So even daughters born before 2005 would be equal partners.
And even if your father is dead,
then as well.
Okay. Provided there's no partition beforehand and things are not already settled. then you would have a right.
So again, a very progressive interpretation of the law, I must say, right? So okay. So now let's come to the Hindu Minority and Guardianship Act. So in the sense that what does this act really talk about, and have there been any changes in this particular act by the Supreme Court or by the Parliament?
See, I will just briefly tell you about this act. This is an act which takes care of the fact that who are the natural guardians of a Hindu minor.
Okay.
And they are, in the case of a boy or an unmarried girl, the father and after him the mother, provided that the custody of minor who has not completed the age of 5 years shall ordinarily be with the mother.
So is this the law under which, say, a warring couple actually fights for
Custody.
the custody?
Yes.
Okay.
Now, here also the act says that 5 years, a child below 5 years, normally it should be with the mother. And court, of course, see, the courts interpret laws as per the facts of each case also. The family courts, when the matters are before the family courts, the courts see the overall situation, you know, who is working, who has the means, or even if the mother, the court has even given the custody of the child to mother even in cases where she is not working, because the maintenance is then provided, or the parents have to take care of the child till he or she attains the age of 18 years. So, doesn't matter if the custody is with the mother or father, but whosoever is earning has to take care of the maintenance, the studies and etc., all the well-being of the child till he or she is 18 years of age. So, again in this also it is kind of gender neutral. The courts now, of course, with the change in needs and society, the women are working nowadays, and both are equally are capable of taking care of their children. So, it depends on the facts of each case, but the law is quite gender neutral in that sense.
Okay. And what about the Hindu Adoptions and Maintenance Act? What is the main objective behind this act?
The Hindu Adoption and Maintenance Act 1956 is basically an act which tells you how you can take in adoption any girl or a boy. Now, I will just briefly, if I can take you to section 7, which is capacity of a male Hindu to take in adoption. Now, this is again a very gender neutral act, because section 7 says any male Hindu who is of a sound mind and is not a minor has the capacity to take a son or a daughter in adoption. That is section 7, and female Hindu is section 8, which is, of course, which was after an amendment which was done in 2010. Now, this says capacity of a female Hindu to take in adoption. Of any female Hindu who is of sound mind and is not a minor has the capacity to take a son or daughter in adoption. Now, provided if the woman has a husband, then of course you have to take the consent of the husband. That is of course a proviso, but what I am trying to specifically ponder here is that this is gender neutral now. It does not differentiate whether you are a man or a woman. It does not differentiate whether you want to take in adoption a son or a daughter. Of course, there are guidelines, the CARA guidelines are there. You have to go through that process and then a legal adoption happens. But the law gives you equal opportunities. And if you just see section 18 of this act, we talked about maintenance under Hindu Marriage Act. Even this act gives says in section 18 maintenance of wife. So, the aspect of maintenance is taken care of by just not one, but even under this act. We of course have section 125 which talks about maintenance. Now, even in these acts, so the parliament has been very cautious to say that women should be given maintenance, and if not under this, then under this. So, section 18 said, and that when we discussed about Hindu Marriage Act, it was gender neutral. Now, he says this act says maintenance of wife.
Very specific.
Very, very specific. And also now maintenance of widowed daughter-in-law, that also is your responsibility. Okay. Third is maintenance of children and aged parents. So, when I was talking about the fact that it also says that we have a law which says that you have to take care, does not matter you are a son or a daughter, but you have to take care of your aged parents as well.
So this is the law which deals with that.
Yes.
Okay, so Archana, you have explained in detail about why there was a need to codify these Hindu personal laws and how these codified Hindu laws have actually helped, particularly the women of the Hindu community, in terms of equality and in terms of non-discrimination. Now the thing is, let's come to the current debate which is now going on, but especially after the Law Commission invited suggestions on Uniform Civil Code. So everybody knows that in India is a diverse country. We have multiple communities, they have their own personal laws, and for many years these laws are being practiced. So why talk about having a uniform civil code now? Do you think that the society or India is kind of ready for a uniform civil code?
Well, the 22nd Law Commission has invited suggestions, we all know, and the time limit is also 30 days. I feel this is not a new debate at all, and just immediately after 2018 it is now being taken up again. See, the fact that the courts have already doing their bit in order to tell the parliament that you should proceed ahead. And at the time when Article 44 was kept in the directive principles of state policy, it was incumbent upon the parliament to think over having a uniform civil code. The parliament did not do it. Probably, see, there are so many things, a vote bank politics or whatever it is, but the fact is that it was not done by the parliament. And the courts, if you just see the 1985's Shah Bano's judgment, so triple talaq was in question there, maintenance. This was 73-year-old lady, and she was given a triple talaq which is irrevocable. And she had to come to the court saying that 125 is applicable on me as well, but that was not given. So
125 criminal procedure.
Yes, CRPC. Which is a secular law, but they said that no, the maintenance aspect is dealt with differently under the Muslim personal laws, and therefore she cannot be given maintenance under 125 CRPC.
But Archana, the thing is that you also mentioned yourself that codification of the Hindu personal laws did not do away with their ethnic practices, right? Correct. So is it possible to have a uniform civil code while ensuring the diverse practices that we have right now, the diverse practices in various communities? Is it possible?
When I say that diverse practices, customary laws is something else. And when you talk about these customary laws and you also talk about the equal rights of men and women, the fundamental rights. Now, when the constitution talks about Article 14, it does not say that a particular religion will not be governed by that. Although Article 13 says that the personal laws, when you are weighing personal laws and the fundamental rights, then the personal laws would govern. But then that is what I am saying, there is a dichotomy. In the constitution itself, you are in a way giving a superior place to personal laws, even though they are detrimental to the rights of women. Now, the grounds of divorce, the maintenance, why should the Muslim women be also given maintenance under the secular law? The word secular was taken in the Indian constitution in 1976, 42nd Amendment. But it was not as if Indian society was not secular. We were secular from the beginning, we were already existing, but the fact that there has to be equal rights given to both men and women, Shah Bano and then Shaira Bano, see, ultimately the court had to declare that triple talaq is unconstitutional because the parliament was not doing it. And you have to see that the women of this country, see, Hindu women already are on equal pedestal. But when you come to the minority community, especially Muslims, you see a lot of practices which are against them. There are few petitions already pending on nikah halala and polygamy. Now, polygamy, you can't really say that this is an essential practicing of Islam.
Okay, got it.
And even, I'll just, sorry, even when this triple talaq case was being argued in the Honorable Supreme Court, it was argued that this is not a part of their essential religious practices. So, Article 25 to 30 gives you that protection only to protect your essential religious practices, but that can't be a reason to not give equal rights to women.
So since we're talking about equal rights, now back in 2018, the Law Commission tried to take a different route. They tried to focus on different laws, even personal laws, and bring in amendments in those laws instead individually to remove gender disparity or to remove inequality within them. What do you think about that route being taken?
See, I would have understood, I was okay if that route was taken 50 years back, maybe when the Hindu law was codified, maybe around that time, 5 years, 10 years. But today, after so many years now, 70 years, more than 70 years of independence, you are talking about, going to the route which would have actually taken care of when we were doing with the Hindu laws. Now is not the time. See, people are all very aware now. It's not that even the younger generation, they want their equal rights, and now is the time that why you want to take a very longer route to achieve the same position where you have to come already. So a uniform civil code, maybe you can actually jot down certain things which are head on against the rights of women. So like polygamy, the fact that it has to be only 2 people in a marriage, which will give you equal.
Maybe age.
Yes, again that is
What was taken care of in the Hindu code, bring in a age limit as far as marriage is concerned.
because in Muslims it is the age of puberty. Now the girls are very young at that time, they are very dependent, they can't take their own decisions, they are not fully qualified, they have not completed their studies. So all these things, they should be immediately removed. And why not? And why just, see, I mean it's my personal opinion, but the road will still be the same. Because when Shah Bano's case came and the court said that you should do something about it, the Muslim clerics were very against it. They said that in fact they went on to even give a fatwa that these are our essential marriage practices and you can't interfere with them, although the Muslim women are completely against it.
Okay, on that note, we've reached the end of this episode. We spoke about the 4 laws that make the Hindu code, and we spoke about how these laws in themselves were of course introduced to remove inequalities, various sorts of inequalities from Hindu personal laws, and they've had their own journeys within the parliament and within the courts so that they could evolve and keep up with the society. I hope you enjoyed watching this episode. Do let us know in the comment section. Thank you so much for watching.